And welcome back to Carolina and Company Live. All right, we got some great people lined up for today. Now, next we got Pat O'Day, attorney on HOA. Now, a lot of you involved in that, so you better listen up.
That's right. From your lawyers at the beach, McCutchen, Mumford, Vaught, O'Day, and Geddie. And thank you so much for joining us today.
Thank you very much for the opportunity.
Yeah, pretty much a lot of the places around here, they do have homeowners associations.
Yes.
So let's talk a little bit about that, because that's a big thing for people.
It is very big.
Yeah, most of your newer developments will be either neighborhood communities, which will have covenants, and of course, if you buy a unit in a condominium, it'll be subject to the covenants of the master deed. In South Carolina, we have a condominium act. It's called the South Carolina Horizontal Property Act, and then your covenants and your master deed also apply to how you live. When you live in the neighborhoods, then you will have the covenants, the rules and regulations that are set forth in the Declaration of Covenants, Conditions, and Restrictions. But our state, unlike many other states, does not have a Planned Unit Development Act, which gives some guidance to associations on how to operate. And that's one of the drawbacks right now. In other words, Florida or Virginia or Maryland are very advanced in their legislation with regard to addressing a lot of the issues that come up on a daily basis in our state and in other states. But we're not the Wild West, but...
All right, I got to ask you a question now. What can members of homeowner association do to undertake if the board of directors do not timely repair the elements of what they have to do?
Oftentimes, members who get frustrated with the board's failure to maintain the common elements. Right. And then they say to themselves, the first thing they do is they say, I'm going to withhold my dues. I'm not going to pay my dues. When you all finish fixing the property, I'll pay my dues. And that's a natural reaction, but it's one that doesn't work. The courts across the country have constantly said it's a separate duty. Duty to pay dues is one, board's duty to maintain is another duty. An owner doesn't have that many options, though. I mean, can complain to the other owners, can write and petition the board, can request a hearing, can seek to get others elected or him or herself elected.
But you have to pay to do.
But you can't just stop paying.
Right.
It's not like your child's allowance you can withhold if they don't do their duties.
Most people think that, and it's a natural thing, but it's a loser.
All right. Here's another question. Do associates have to answer condominium certifications, which are being routinely requested by lenders?
In the condominium world, our lending institutions are required to certify to FHA certain information in order for FHA to underwrite a loan for the condominium unit. The lenders are then turning to associations and sending them questionnaires saying, you all certify this information to me, and then they're passing it on to FHA. The associations do not have to certify, and I would urge any board that is signing these certifications to take a breath, to just say to the best of our ability, but they're putting in those forms that you certify that this information is right. The federal penalty is 10 years in jail or a $1 million fine for incorrect certification.
False certification. You learned something today.
Yeah, and if you have any questions, these guys are the guys to ask, and you can go to yourlawyersatthebeach.com for some more details. And if you have any questions pertaining to anything, you can email us at legaladvice@wpde.com, and we will pass those questions along and get them answered for you. All right, thank you so much for joining us. Stick with us. More coming up next.